Our next speaker will be Professor Robert Sloane from the Boston University School of Law.
Thank you. First of all, I want to say, as many have, but it's particularly true for me, it's a real privilege to be part of a dialogue with so many distinguished lawyers and philosophers who I've read for many years and admired, including, of course, Professor Dworkin. About 8 years ago, I wrote an article on human rights, the subject on which I'll be speaking, from the perspective of the fox. So it's interesting today to try to respond to some of the arguments in manuscript on behalf of the hedgehog. The argument about human rights in hedgehogs is not a legal argument, of course, or at least not primarily, right? It's primarily not about how to interpret post-war conventions. It's really about the moral, underlying moral principles of human rights. And Dworkin makes this explicit in some other works like Is Democracy Possible Here? So what I'd like to do is briefly explain what I understand the account to be and to raise 4 particular objections or perhaps just questions about the account. Those 4 objections, in the event I don't get to them, I'll list them first. It strikes me as unduly vague and indeterminate, which is problematic and particularly strange for part of Professor Dworkin's jurisprudence. Second, I think like every effort to ground human rights in objective or avowedly objective moral foundations, it's ill-suited to a contemporary public international order that's characterized by diversity and pluralism at multiple levels, political, cultural, and moral. Third, I think it's a methodological error generally to try to derive human rights from an antecedent conception of human dignity rather than to construct human dignity from a conception of human rights, which is how I think historically things worked. And finally, I think just a minor point, it's somewhat anachronistic and also incongruous in hedgehogs that Professor Dworkin, as I understand it, conceives of sovereignty as a principle that's in tension with human rights, rather than one that can best be defined in terms of human rights. You would think that if liberty and equality can be reconciled in the appropriate way, the best conception of sovereignty, philosophically, would be one that is supported by or consistent with human rights. Now, Dworkin defines human rights, as many do, as the rights we have just because we are human beings. International law might instantiate those rights, it might not, but it wouldn't be an objection to the account in Hedgehogs simply to point out that there are divergences between the rights implied by Dworkin's account and those on the book, so to speak. It might, though, be an objection to point out that there are pretty severe divergences, or that we end up with a list of human rights that is radically different in some respect from those that we generally consider to be real human rights. At the most abstract level, I think the normativity of human rights can be defended in one of 2 ways, either by defending or by disavowing moral objective foundations. And Dworkin, of course, adopts the view that you have to defend moral foundations. My own view is that you're better off disavowing any moral foundations and working from a different perspective. The problems that afflict foundationalist accounts, in my view, are twofold at least. One, they are always unclear, and second, they are always invariably in practice controversial, even if theoretically coherent. Okay. I want to paraphrase Michael Ignatieff, whose writings on this subject I very much admire. He says, it's tempting to relate the idea of human rights to propositions like all human beings have an innate and a natural human dignity, self-worth, they're sacred, and so forth. But these propositions, quote, confuse what we wish men and women to be with what we empirically know them to be. And they're also controversial because each of them must make claims about the ultimate ontological status of the world that is intrinsically contestable. So theoretically, I worry that Dworkin's account, even if it were right, is strategically perhaps misguided from an advocacy perspective, in that it may not be the best way to actually realize the best protection of human rights that we can have. So what's the account? Well, very briefly, we have the 2 principles which have been discussed at some length in some of the previous panels. Self-respect, Once a human life begins, it objectively matters how it goes. It has an adverbial value. And second, that each person has a special, personal, non-delegable responsibility for defining and then pursuing what he or she regards as a coherent narrative and giving value to their own lives. For Dworkin, as I understand the account, the distinction between human rights on the one hand and political rights on the other, and then legal rights as a subset of that, lies in the degree of abstraction appropriate to each. So within any particular liberal polity, we are entitled, we being citizens or people, to the, quote, best understanding of what the two principles of dignity properly interpreted require. For human rights, though, what we're entitled to is not the best understanding, it's just a good faith understanding. We're entitled to an attitude of respect towards those principles, a reasonable way of trying to interpret the principles, and so long as that's done, our human rights are respected, even if the officials happen to get it wrong. To my mind, the most immediately striking feature of this conception, in light of what I've read of Dworkin and how I understand his prior jurisprudence, is that it seems to render human rights radically indeterminate in hard cases, right? Because not just as a practical matter, not just in the sense that empirically we might not be able to discover the right answer, but so long as we have two officials from different polities and they're each interpreting in good faith the two principles, right, then we have two different conceptions of human rights that are both consistent, right? They both respect human rights, even though they may be very different. That also means that if, say, a judge on the European Court of Human Rights is trying to interpret particular institutional history, once the fit dimension is exhausted, and the judge then looks for the principle that best justifies, well, there are multiple moral principles. And according to the account, as I understand it again, it's not necessarily that one principle is, or we're not obliged, state officials are not obliged to adopt one interpretation rather than another, so long as they act in good faith. So legal as well as moral human rights seem to be indeterminate. What this amounts to is a kind of thin conception, as I see it, of international human rights. The human right to freedom of expression, for example, might or might not guarantee neo-Nazis the right to march through a largely Jewish neighborhood. It might or might not guarantee Danish newspapers the right to publish critical cartoons caricaturing Islam. We may or may not have a right to health care. On these issues, individuals can have very different opinions reasonably and in good faith, I think. Let me give one example. Okay, let's suppose that there are two states, Ruritania and Azania, and Ruritania decides that a good faith effort to respect the two principles requires it to recognize a robust right to health care because its officials reason that a person's life goes better quantitatively and qualitatively if that person has reliable and secure access to health care. That seems reasonable. Azania, another country, says, no, that's wrong. Actually, it's misguided because it requires too radical a distribution of legitimately required wealth, and people need that wealth in order to pursue what counts for them as success in their lives. Well, it seems to me that we don't have any way of adjudicating as between those two conceptions. The result is that the only human rights that are morally incumbent upon states, and perhaps other actors in the modern era, is the lowest common denominator interpretation that is consistent with the two principles. And it's a very parsimonious understanding of international human rights. Now, very quickly, two final points. As I understand it, what matters for international human rights is not the metaphysical fact or the ontological fact of whether value pluralism is correct, but rather just the empirical fact that there is value pluralism in the world. And Professor Dworkin acknowledges this very clearly, that anthropologically, psychologically, and so forth, people do evince an astonishing diversity of values. As long as we have that in order to get to universal human rights, it's going to be more productive to try to work from something more akin to an overlapping consensus or a Rawlsian type view. Final point, as I mentioned at the beginning, prior to World War II, sovereignty was indeed conceived as a kind of black box notion, so that what went on within a state was a matter solely within the domestic jurisdiction of that state. But precisely the point of the international human rights revolution that historically took place in the wake of World War II and in response to World War II was that in certain situations, it's not that human rights trump sovereignty. It's rather that we reconceptualize sovereignty not as the divine right of kings, as it started out in Westphalia and to the, maybe to 1945 or so, but rather that sovereignty now means popular sovereignty. It now means something more along the lines of rights to democratic governance, participation, voting, and other international human rights. So I think those two conceptions are actually consistent, and I find it surprising that in the Hedgehogs manuscript they would be deemed to be inconsistent. Thank you.